The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Three cases will be submitted this afternoon. Those cases are in the matter of James Martinek. Second case is Glendale Moore versus State of Iowa. And the final case is State of Iowa versus Sojay Olatunde. That last case is now submitted to the court without an argument, and we'll hear the arguments in the first matter. Mr. Cmelik.
May it please the court. The commission applies to this court today for a public reprimand against Magistrate Martinek because of his advertisement on a personal internet website that advertised both his services as an attorney and services as a judge as well. The commission found this case to be controlled by Henry Meldrum, and in a very short and concise decision found it controlled the circumstances. But I think there are some subtle distinctions that I should probably point out and discuss with this court today. Certainly the advertisement, the photographs of the judge in robes on a personal attorney website is reminiscent of Meldrum. And in fact, as a matter of fact, in this case, the commission found that it was the judge's intent to advertise both his services as an attorney and his services as a judge for purposes of marriage.
Am I correct that in order to actually see him in his robes, you had to click on the link having to do with wedding ceremonies?
I think, as I understand, it was a tab on that website that just turned you to a different page of it, but I might be incorrect about that. But it certainly is a different page.
He wasn't using the robes to advertise private legal services. Is that a fair statement?
I don't know that that is a fair statement. The commission certainly found that that wasn't the case. They found that it directly did inform people that might visit the website about his status, about his position, and that would influence their decision-making if it was to employ somebody for legal services as well. So in that sense, it is like Meldrum, but it is different than Meldrum in a very significant sense as well, and that is that you have a judge who's advertising his services as a judge to perform marriages.
Well, it's kind of a sort of a funny situation. I mean, it's a service as a judge, but it's a private service you're allowed to perform because you are a judge, right?
That is correct.
And the question I have is, since you're allowed to do wedding ceremonies off regular business hours, off-site, for $200, what's wrong with telling people that you can do it?
Well, certainly, as I point out in the brief, there are 4 commissions across the country that have said it is improper despite statutory authority to do it. And I think that really is at the heart of the question here. If there's something that's authorized by statute and the court is permitted or a judge is permitted to provide this service for a fee, does it somehow abuse the prestige of the office for the judge to advertise that particular service and in fact turn it into a cottage industry? And I think that's where courts that are concerned about the integrity of the judicial process and the bench itself don't like the fact that there's advertising being done for personal gain that turns the position of judge into an avenue for personal gain through these marriage ceremonies. And I think that, again, the question becomes, can you abuse your prestige by doing something that's statutorily authorized?
Would your opinion be any different if he advertised his wedding services under, wedding services in the Yellow Pages?
I don't think it would be. If you're using your position as a judge, portraying yourself in your robes and offering this service, which the commission found was misleading in that it suggested you had to come to him and pay the $200. Now, his testimony was that he would advise people who contacted him through the advertising that you could do it for free at the courthouse, but this is something I enjoy to do. I have all these sites picked out that are nice places to have weddings, and I really enjoy doing it, so come to me, pay me the money, and I'll do it. Didn't mean he didn't discount.
you know, in Colorado, you know, which I think you cited that opinion, I mean, as I understand it there, what they said is appropriate is you have a website and that's paid for by the taxpayers, run by the clerk or the county recorder or whatever, that says these are judicial officers who are available to perform off-site weddings. You may contact them. What is it that makes that okay and not Magistrate Martinek at his own expense, on his own time, communicating information in arguably a more effective way?
Well, and I think that's part of the problem in a more effective way, because you're turning what is authorized by statute into a cottage industry, a personal gain. An independent website run by the court provides information. It's almost like a public service announcement. Here are the individuals available. You can contact the court and arrange for a wedding, and we will assign someone to do that. On the other hand, if the judge himself has a website in which he says, I perform these weddings for $200, here's the kind of services I provide, and tries to make it glamorous, tries to make it appealing, you're turning the judicial office into an advertising system for marriages.
Was the problem that he didn't list, what if he had listed, by the way, here are these other judges also available, here's their contact information, like Colorado, only it's his private website?
Well, again, I think it's significant that, and I do have to acknowledge, and I will say this up front, the Colorado canon seems to be a little bit different than the Iowa canon as well, but it talks about the exploitation of the office, just not the abuse of the prestige of the office. And so Colorado is concerned about a judge exploiting his position as a public servant to obtain financial gain. And that's what is at the core of the problem here. That's what creates the kind of appearance of impropriety that brings into question the integrity of the court. Listen, I'm going to take my position as a public servant and turn it into this money-making opportunity for me through advertising, and although not overbearingly in this case, but one could imagine how extensive the advertising could get, and how how it really would seek to draw people in and create really another avenue of income for a judge because of his position as a public official.
I understand kind of his version of events is that this all really started after Varnum. There was tremendous demand for same-sex couples that wanted to get married, and in order to handle the demand, he made information available, which was a service to those people, wasn't it?
Yeah, I think the problem is the service was being advertised, again, for personal gain. I think the testimony was in the case, as many as 2 or 3 calls per week came in, which created the possibility of $200 3 or 4 times a week, and even there were busloads of people coming in, and you could do 17 weddings at one time and look at $3,400 in income because you've put yourself out there, tried to attract people to come to you as opposed to other members of the court, or to contact the court to arrange for a wedding that could be provided free within the confines of the courthouse. I think that's a substantially different situation where you are trying to attract people to you as a judge using your public office for financial gain, and I think that's what the rule talks about.
But from the standpoint of somebody that's looking for someone to get them married, isn't it more beneficial if there's advertising out there, if they can run a search on a search engine and get a name of somebody? Doesn't that help them?
I think it's I don't think it's a question of whether it helps somebody. It's a question of whether we want the judges to be providing the advertising and the information and trying to attract someone to themselves. Again, I think it's a laudable public service if we have a website that's attached to the courthouse, which says judges provide marriage services. Here's a list of those willing to perform that, and you can contact and we'll assign. And I don't think there's any problem with that particular approach. The unseemliness of it, the appearance that holds into question the integrity of the court, is all based upon this advertising and soliciting and trying to use it for your own independent source of revenue, as opposed to just being a judge who's in the courthouse who will be assigned to marriage for people who want to come in. I think that's substantially different. I think what the rules try to avoid, again, is creating a circumstance by using your office for personal gain. If you want to perform the weddings in the courthouse for free, there's no personal gain. Would advertising those free services be a violation? I don't think so, but I think when you turn it into a cottage industry, when you turn it into a real source of revenue for yourself as a judge because of your position, that's what the rule seeks to avoid.
Back to Justice Mansfield's point, isn't this useful information for the public? I mean, I think a lot of people want to get married on a Saturday and at a venue other than the courthouse. And for those who do get married for free at the courthouse, that's taken that judge or magistrate away from their other duties. Why is this a problem?
I don't think, I mean, I think it is a useful service, and I have no quarrel with that. The question is whether we want judges to advertise those services through glossy websites that attract individuals to them for the purpose of enhancing their income, as opposed to just simply providing a service. Now, it may do both, but you can't divorce the fact that it is a substantial source of income for a judge that he gets position. And I think that is something that the rules is designed to prevent. Judges aren't supposed to use their position for financial gain.
On the sanction, he as soon as the Meldrum case came out, he took the photos down. Is a public reprimand of the right sanction, or is this more of a instructional public admonishment situation?
Well, I mean, I think that in the sense that Judge Meldrum, or Magistrate Meldrum was sanctioned, not knowing that the conduct was against the rules and not knowing that he committed a violation, it's just appropriate here. He's in no different situation than Judge Meldrum was at the time. So I do think it's an appropriate.
Well, it does seem to me a little different. I mean, in the Meldrum case, the commission's theory, which we accepted, was that he was using the prestige of the judicial office to drive people toward his law practice. Here, he's using the judicial office to drive people towards a service that he can only provide because he's a judge. So I struggle to see the exact analogy between the two cases.
And indeed, I mean, I started out with saying I don't think it is an exact analogy, but I think it's equally as concerning. And I think, first of all, there is the exact same problem that Meldrum had, and that is the commission did find that it did solicit services to him as an attorney as well. It did improve his appearance through the website to members of the public because of his position and whatever advantages that might create for them if they were to hire him. So that's one part of it. That's the Meldrum part. But there's also the more direct financial gain by advertising your services as someone who provides marriages or conducts marriages. That's clearly a much more direct income avenue for him. It clearly paints a picture of actual income increase. I mean, we can theorize about why clients may come to somebody because they're a magistrate, but to draw a direct analogy, say there's X amount of income earned because of the advertisement, is almost impossible. But here we can say, we can look at an actual number. There's $200 each marriage. Now, I understand it wouldn't have been $200 for every marriage, and there were in fact some discounted, some done for free, but it is a direct source of income that you can see coming to the judge as a result of the advertising. And that seems to be more concerning than the kind of indirect avenue of income that would come to Judge Meldrum.
In your view, any effort really to get the word out beyond word of mouth is improper? Is that right?
I think for a judge to take the horns and be the person advertising and then trying to bring those individuals to him personally to provide that service, to him personally to obtain the income, that's the problem. If the court as an administration wants to provide the information through public service announcements, through their own website, I don't think that creates any kind of problem, and it perhaps should be done. There are people out there looking for this service, and they should know about it. But to have a judge advertise his own personal time, efforts, and the kind of circumstances in which he would perform it, it does something other than just provide a public service. It provides a source of revenue.
Could you see the... Oh, go ahead.
No, I just have a question. Practically speaking, I think they indicated that there was a notice that said these are the two magistrates and one district associate judge who would perform it. And how are the people directed to make contact with them? Were they to contact them at the courthouse through their local in the courthouse phone number? I mean, I just don't understand how we get from there, all of a sudden, then we go to the magistrate's private office.
Well, I don't remember what the specific mechanism is. I mean, obviously, if the clerk of court is contacted and asked about services, she could give a number to
Well,
the...
and what I'm thinking about is that oftentimes at courthouses that I've been in, then they just have a notice that said, so-and-so magistrate will only perform weddings, you know, from 2 to 3 o'clock on Thursdays. And so everybody's, when they come to the courthouse, they're just put on notice of the fact, these are the people who will do the weddings, and these are the times in which they'll do them. There's no direction to a private office or anything, and I don't know if that's what happened here or what.
Well, I don't think that is what happened here. I mean, there was some testimony in the case about how the contact was made through the clerk first, and only after the clerk received the information was the website divulged. But in fact, what happened, or could have certainly happened, was it was readily available through a Google search, and it could be found by anybody looking for it. So we would ask that the sanction be imposed. Thank you.
Thank you as well, Mr. Cmelik. Mr. Kilburg.
May it please the court, counsel. Your Honors, I think that since so much of this case springs off the Meldrum case, it's important to take note of what the court said there. The purpose of judicial discipline proceedings is to restore public confidence in the system and its officers, not to punish the individual judge. And so even if the court were to find that there was a violation of the judicial standards here, we think that a public reprimand would not be appropriate in the limited standards and facts of this case.
Do you think there was a violation of the judicial canons of ethics?
Your Honor, it sounds like what the court is really struggling with here is the question of information versus solicitation. To the extent that Magistrate Martinek provided information, I don't think there was. To the extent that the court finds there was an act of solicitation, it could argue it could be construed that way. Based on the testimony that Magistrate Martinek gave at the hearing, I don't think so. I could see where maybe this court would go the other way on that, but I think the evidence weighs there was informational purposes, not solicitation.
The commission may have a point to the extent they're saying, you know, maybe in the interests of fairness and full disclosure, and because judges are supposed to be purer than Caesar's wife, that you should have had on the website a statement. You can also come to the courthouse and get for a free wedding ceremony during regular business or during my regular judicial hours. You agree with that?
Maybe that's a good idea for the future. It's something that would be sort of the new best practice emerging out of this, but the testimony was pretty clear that anyone who saw the website and was interested in retaining Magistrate Martinek's services was directed to call him, and when they spoke with him, he said, by the way, I can do this for free at the courthouse. So I think that maybe there could have been a slightly better way, but the crucial information was clearly provided to the public.
Well, you can answer my question perhaps then. What's your knowledge of what the record is here? Is the information simply provided at the clerk's office and then they're directed to his private office? Are they directed to his website?
I believe, Your Honor, and I apologize if I get it wrong, but I believe that if people went to the courthouse, they could then be given his number to call him directly.
At his private office?
Yes, I believe so, Your Honor. Or though I would also imagine, you know, if he happened to be holding court that day in the appropriate time, they may just direct him up to speak with him directly. But so because this is also a case that has sort of further reaching implications for the future, I think it's important to take a look at whether the suggestion of a public reprimand would actually serve the underlying goals that this court seeks to advance in its consideration of judicial discipline. One of the big things that's weighed there is the nature of the violations. This was an isolated instance of what may be problematic behavior. And like I said before, this is really a question of information versus solicitation. We're not trying to gloss over the fact that this was obviously a publicly available website, but it was provided in order to tell people hey, you can come to me for this particular service. Now, there was some discussion of, well, what if people just went to the courthouse? They could be directed to a magistrate or a district associate judge there, but that wouldn't necessarily inform people. We can also do these weddings outside of the normal court hours. So I think that's the informational aspect of the website that's at issue here, is that there was information about the expanded scope of what Magistrate Martinek could do. It's also important.
Wasn't the picture in the website a picture of him with his robe on?
Yes, Your Honor.
Right. Well, how does that play into your argument that this was just informational?
I think, I guess it's just sort of provide information. This is one of the things that I can wear. I believe there was a little bit of information there. You can choose generally what I wear. If you would like, I can wear my robe if I have time to go get it from the courthouse, if you're doing this on an expedited basis. So kind of letting people know that if you want the robe, you can have the robe.
You know, wasn't that website attached to his law office website?
It was, Your Honor.
And excuse me, I'm sorry. And he's using the robe, I mean, in connection with that website? I mean, that seems to be using the prestige of your office not only to advertise for weddings, but also, you know, indirectly say, I'm a magistrate, maybe you want to use my legal services too.
Well, Your Honor, that kind of stems off the Meldrum opinion here. And I'm not going to deny that may be problematic, but then I think it's important to take into consideration that just a few days after that opinion came down from this court, Magistrate Martinek affirmatively called Mr. Boyd of the commission, got in touch with him, wrote a self-reporting letter on the basis of their phone conversation.
But shouldn't you have known that before the Meldrum decision? I mean, I think was the Meldrum decision that groundbreaking? I mean, it's such new law that no one in the country has ever done anything like that?
That's not what I'm claiming, Your Honor. I'm not saying that Meldrum announced this sweeping new standard, but I think it perhaps provided some clarification, and if nothing else, I think it properly contextualizes the fact that this was an affirmative act of self-reporting, not that this is something that nobody ever thought about or could have thought about before. But like I said, I think that it shows that as soon as he's alerted that there might be a problem, he did something about it.
I shift gears a little bit. As I understand it, your client's now no longer a magistrate, is that right?
That is correct, Your Honor.
Now, the last time this situation was kind of arising, there was some discussion about mootness. Are you contending or are you making any argument that the proceeding is moot?
Your Honor, I think it certainly could be viewed that way. I think it also goes to the inappropriateness of a public reprimand in this case. One of the goals there is to kind of protect the public. It doesn't serve that. There's certainly no more allegations of any problems with the website, which has since been sort of scrubbed. Any reference to any service as a magistrate has been removed from that. But I think it could very easily be viewed as moot because he's no longer a magistrate.
Well, do we have the power to sanction somebody for a violation of the judicial code when they are no longer a judge or magistrate?
That's a very good question, Your Honor. I guess I'm not really sure. That really presents a real mootness issue, Your Honor. I wish I had thought of that beforehand, but I think it's something that's worth considering for the court. The other thing that I'd like to bring to the court's attention as well is sort of the larger deterrent effect. That's one of the court's goals in weighing judicial discipline. For whatever arguable deterrent effect of other problems arising that a public reprimand or other sanction would have in this case, I think any benefit of that would be greatly outweighed by the notion that if I look at my website or if I look at my materials and maybe they're slightly problematic, maybe it's better if I just scrub them, if I just brush this under the rug. And I hate to say that's maybe something people would think about, but I think it's something that has to be acknowledged, that there might be an impulse for people to just avoid the problem entirely, and it sort of punishes the act of self-reporting, of affirmatively cooperating with the commission to the extent that Magistrate Martinek did. And I really like for the court to be conscious of that, of the message that it's sending in the larger context. And that sort of thing isn't really better serving any of the goals this court sets out for. I believe one of the other issues that was discussed, at least in the briefs, was kind of the idea of restoring faith in the court system. I believe this is being either live streamed to YouTube or soon will be. And I think that it really shows that both the commission and this court are taking seriously their duties to police the judicial system, to pay attention to what's happening, and for members not only of the bench but also of the bar to take their duties seriously, to engage in critical self-reflection, and to be very cautious of their ethical responsibilities. As you noted, Your Honor, Magistrate Martinek is no longer serving on the bench, but there were some discussion of some other cases here. I also want to draw just very quickly a little bit of attention to the case in Wisconsin, just to make sure that I can distinguish that. That was the Latch case. The judge there was, it was found affirmatively seeking to advertise his private practice in the advertisement that was at issue. But also one of the things that the court there in Wisconsin found very important was that he had also presided over matters involving close family members. And so I think that really makes the imposition of the discipline in that case distinguishable from the issues here, just sort of a difference in levels. And so really as the final question, what do we suggest the court does here now that we're in front of you? I think the court could realistically find that there was no violation based on, again, the information versus solicitation divide that I had discussed earlier. But if the court were to find that there was a violation, unfortunately, as the court previously noted in Ray Kroll, a private reprimand is no longer available. But I think that the court can sort of say, going forward in the future, this is definitely something that is problematic. It should not be done anymore, to sort of establish or reaffirm a brighter line rule coming out of Meldrum, or to at least remand for consideration based on the factors that this court thinks are important coming from this case. So remand back to the Judicial Qualifications Commission. So unless there are any further questions, Your Honors? All right, thank you very much.
Mr. Kilburg, thank you as well. Rebuttal argument?
May it please the court, just a couple.
Mr. Cmelik, you know, I never let you talk. I apologize.
That's all
when
right.
you do your rebuttal.
All right.
I mean, but I think, you know, and I didn't really realize this, doesn't the Holeen case say that we have no jurisdiction on this anymore once he resigns?
Yeah, quite frankly, I haven't looked at the Holeen case. I know that there was some kind of settlement made in the Holeen case that maintained her retirement rights and things like that.
It was worse than that. What happened in the Holeen case is that Judicial Qualifications ordered removal. And removal required, the discipline that went along with removal was loss of your pension.
Right.
The Supreme Court said she's removed as of X date unless she resigns by midnight, certain date. And which then tells me that, and she did resign. I remember it was 11:59 because I was chair of the Judicial Qualifications at the time.
I remember that.
But she did resign, and the Supreme Court, I think, took the position, if you read Holeen, that there's no more, although they ordered her removal, they couldn't really do the removal and taking away her pension benefits because she resigned before the sanction took effect. So it seems to me that if we're going to follow the spirit of Holeen and the ruling of our prior court, that there is a problem. So help me out here.
Well, my concern is, again, if the sanction that's imposed is not about punishing the particular judge, as he argues here today, it's about restoring confidence in the system. It's about sending a message to the public that we will not tolerate this kind of behavior, then a public reprimand that doesn't require any other kind of action to follow doesn't require the taking of any kind of benefits, doesn't require any further execution, then it would seem to be appropriate to go ahead and issue that public reprimand.
But you know that when a judge is charged, and maybe it's my inside knowledge, and maybe I shouldn't be speaking or should swear me in or something, but when the Judicial Qualifications Commission files a complaint and a judge resigns prior to the hearing, the matter's dropped because I think the rules and the statute indicate that there's no longer jurisdiction to discipline. And if they don't have jurisdiction to discipline, why would we have jurisdiction to discipline?
I'm not so sure how clear it is that they lack jurisdiction. I think it might have been a matter of discretion. I certainly have been involved in cases where discussions of that nature were taken, and I don't dispute what you're saying here today. I don't know whether that says anything jurisdictionally about a case that, one, had completed the hearing at that particular level and actually had applied to this court for imposition of the sanction. And again, I think it might be different since we aren't asking for there's nothing to execute, there's no further action to take.
That's,
it's just the issuance
that's why I
of the
brought up the
order.
Helene case, because it got as far as it could ever get.
Yeah.
And the court thought it would be better to allow resignation, lose jurisdiction, and not have the full consequences.
And in fact, that discussion was had in Meldrum, but again, I think that there is an exercise of discretion. The commission has the ability to dismiss a complaint if they think it doesn't warrant any further action. I think that might fall under that particular discretion. I do want to say just one thing about the isolated nature of the violation here that's been suggested. Let's not forget that this website was operating for 4 years before the Meldrum case was decided. And it was only after the Meldrum case was decided that it was this website that the photographs were removed, although the marriage information remained on the particular website after that time frame, and only after discussions with the court administration was further action taken. So it's not simply an isolated incident. There's a long time frame where this information was contained on the website and solicited, I submit, business for the judge. And I'm tempted to stop now, Justice Wiggins, unless you want to follow up on your...
You know, I'm looking at the jurisdiction, and the jurisdiction's in 602-2101.
Yeah.
And it says the Supreme Court may retire, discipline, or remove a judicial officer from office, or may discipline or remove an employee of the judicial branch for causes provided in part. If you're not a judicial officer, how do we have jurisdiction?
Well, I mean, the problem, of course, is that statute doesn't really answer the question about whether the proceeding has already begun and, in fact, was near the end stage at the time that the person resigned. So, in fact, we had gained jurisdiction. We had obtained jurisdiction. I submit that that jurisdiction continued until resolution of the case, especially when you consider the purposes for Judicial Conduct Committee and the purpose of representing something to the public and restoring confidence in the process. So I would ask that you impose the sanction. Thank you.
Thank you as well, counsel. The case then is submitted, and we'll now hear the arguments in the Moore case.